Good morning, good afternoon, or good evening, depending on where you are in the world, and welcome to Finnegan's webcast, Cars and Patents, IP Trends, Strategies, and Autonomous Driving Patent Landscape. My name is Philip Eklum, and I'll be your moderator today. It's my pleasure to welcome our presenters, Anthony Delmonico and Ming-Tao Yang. Ming is a partner in our Palo Alto office, and Anthony is a partner in our Washington, D.C. office. Both Ming and Anthony have significant experience litigating and counseling clients on IP matters, including in the automotive, artificial intelligence, and autonomous driving technology areas. Brief summaries of their bios and contact information are included at the end of our presentation. Now, before I turn things over to our presenters, I invite everyone to please feel free to participate by submitting questions during the presentation. This is an interactive webinar, and we are very interested in seeing your questions on today's topics. To submit a question, just click on the red Q&A button at the bottom of the webcast interface and type your question into the Q&A window and then click Submit. We will answer a few of your questions today during the question and answer session, which will take place at the conclusion of our presentation. Now, just as a quick reminder, you can enlarge the slide window at any time by clicking on the green Enlarge Window button at the top right of the slide window. The slides will advance automatically throughout the event. And if you are experiencing any technical difficulties, please click on the yellow Webcast Help Guide button in the lower center of the webcast interface. So now I'll turn it over to Anthony and Ming to begin our presentation, Cars and Patents, IP Trends, Strategies, and Autonomous Driving Patent Landscape. Welcome, Anthony and Ming. The floor is yours.
Thank you, Phil. Hello, I'm your first presenter, Ming-Tao Yang. For today's webinar, we will first focus on identifying the leading companies on owning car patents and also the technological area they have been patenting. So now we want to look at what are companies betting on in automotive technologies. So the first area that I will discuss is autonomous vehicles. So we all have high hopes for the future of innovation, and I have a dream that my daily commute would look like this one. Autonomous vehicles, or even visible or invisible bubble that like what you're seeing right now, will take us everywhere. So we will look at what companies are patenting our future. So this is a pie chart showing the U.S. patents relating to autonomous vehicles in the last 9 years. So as you can see, there are about 6,500 patents total. And Google or Alphabet is the leading company in patenting in this area. Right behind Google, there are Ford and Toyota and GM, which is not surprising. But next to GM, you also see two companies in different industries, iRobot, which is in the robotic vacuum business, and Boeing. But they are there for obviously very different reasons because they also have technologies, but not necessarily for ground transportation. And other than those companies, you start seeing from the top 10 some additional companies who also patent very heavily in this area, and one example is IBM. Another surprise is State Farm Insurance. After that, you have Uber, you have Magna, which is a component supplier and technology supplier in this industry. So knowing the leading patent owners, who the leading patent owners are, we will next take a look at the keywords that came up very frequently in autonomous vehicle patents. So out of 6,500 patents in the last 9 years, as you can see, starting from the left, sensors and images are very critical to autonomous vehicle operations. So you see sort of two large areas occupied by those keywords. And by the way, in this diagram, the size of each keyword cluster or area represent the number of times they show up in the 6,500 patents in the last 9 years. So moving toward the right of sensor and image data, you see several cells relating to power transfers. So there's wireless power, wireless energy transfer, and electrical power. So as you can see, in patents relating to autonomous vehicles, the power transfer, the charging remains a critical component in many of the patents. And moving toward to the further right of the 3 power-related keywords, now you start looking at patents relating to individual components like computing devices, video camera, control units, and also, as you can see, user input, autonomous vehicles are very dominant keywords. But in addition to that, at the very bottom right corner, there's a small area that involves a lot of patents relating to mobile devices. And as you can appreciate, autonomous vehicles has a lot of intercommunications, interactions with the outside world, and also with the users. And mobile devices can be a component in some of these patented technologies. So now, knowing what the keywords are, we do want to dive into the different technologies of autonomous driving a little bit. And it's fair to say that it's dazzling to look at some of the latest and brightest patent publications in this area. And as you will see, autonomous vehicle is not just about making the impossible possible, but they can be about many different areas. They can be about user experience. They can be about making the best of competing technologies. And they can also be about how cars interact with the outside world, including pedestrians. So this is the first example, which is a very recent patent publication from IBM. It was published in April. So we know a lot of innovations about autonomous vehicles can be about the hardware or the software itself. But this is one of the patents that talks about user experience. The title is Autonomous Vehicle-Based Guided Tool Rule Selection. And it might not be apparent, but the rule selection is really about bringing different experiences to different passengers. So, for example, an 80-year-old grandma may enjoy a driving style that is very different from a group of teenagers in the car. So this patent talks about sort of passenger or user preferences. It's not just about driving style. It can be about the temperature in the car, can be about the music you want to hear, can be about whether the sunroof should be open or closed. So this patent talk about using, relying on user input and also relying on past driving experience, including different driving routes. So, for example, taking a scenic route versus taking just a typical highway may bring different user experiences. So this patent publication talks about considering all these factors to make sure that when a passenger enters into an autonomous vehicle, she or he can get the type of driving experience or a passenger experience that the person wanted. So the next example is more about technologies, but it's about using the best of both worlds. Many of you know that there has been constant debate about which sensor technology should be the best solution for autonomous vehicles, whether it's LiDAR or it's camera-based detection. This one, again, a very recent patent publication less than a month ago from DeepMap Inc. In Palo Alto, California, talk about how you integrate the data set from LiDAR and the data set from cameras, because they have different coordinates, they have different timestamps, they have sort of different sensing or data processing frequencies. But rather than debating about which technology is the best, this patent publication shows that you can probably be the best of the best by combining two technologies and using both of them to make sure that you get the accurate data you wanted. So as you can see on this slide, on the diagram on the right, you can see two different detectors. One is LiDAR, the other one is camera. And on the flow chart on the left, it talks about how you do conduct time shift between two data sets to make sure that they are synchronized accurately and to allow the driving system to process this data. So moving on to another example of autonomous vehicle technology, again, a recent publication. So typically when people think about autonomous driving technologies, they think about how a vehicle operates itself, how a vehicle avoid pedestrians or be a safe driver. But at the same time, you also, just like typical drivers, they can indicate and interact with pedestrians by moving the car a little bit, by honking, by sending other signals to pedestrians to make sure that their intentions are clear. So this patent publication is about influencing or interacting with passengers. So this is an example of a car at an intersection with a pedestrian either on the crosswalk or very close to the crosswalk. So if the computer is not feeling very comfortable that the computer is aware of the exact intention of a pedestrian, the computer can either generate certain sounds, like sounds of engine or screeching tires, or even audio prompts to make sure that the pedestrians are aware of incoming vehicles. So by doing that, it may change how the pedestrians behave. And after that, the computer or the autonomous driving system would have updated data, better understanding the intention of pedestrians, and as a result, be able to drive even more safely rather than having to guess and make a mistake. So although today's topic is about autonomous driving, and we just look at some examples about latest patent publications, I do also want to give you sort of a general lay of the land about who are the leading companies in terms of patents in different areas that also relate to cars. So the next technology area we look at is electric vehicles. So switching to electric vehicles in the same 9-year period, you are actually seeing, or maybe I should say a little bit over 9 years, so it's close to 9 years and 4 months. So in that same period, you're seeing a much larger number of patents. So compared to 6,500 patents relating to autonomous vehicles, we have over 42,000 patents that are related to electric vehicles. In terms of the leading patentees, it's not surprising that the top 5, Toyota, Ford, GM, Honda, the first 4 are car companies, and after that there's GE. But after GE, there are more car companies or car component companies. So as you can see in the list of top 10, other than GE, everyone else who is heavily patenting on electric vehicles, they are all in the car industry. They are either car companies or suppliers of components or technologies. But knowing who the major patentees are, we will share with you a little bit about the keywords from this patent. So starting from the right, of course, electric motor is a major part, but toward the right of electric motor, there are many patents involving the control of electric vehicles, many patents involving storage devices. So different patents use different keywords, but just looking at this chart, there are 3 or 4 areas relating to the power sources. So you have a storage device, battery pack, power source, and battery module. But you can also see that there are many patents that talk about fuel cell or DC power. But moving toward the left side of this slide a little bit, then you start seeing that for electric vehicle designs, there are technologies or patents that is about integrating with other portions of the cars. So, for example, there are electric vehicle patents that also relate to vehicle body, vehicle doors, and vehicle seats. And not surprisingly, hybrid vehicle, which have been very popular in the last 10 years, is also very heavily patented. So the next area we will look at very quickly is another area that is full of new technologies. Many of you know about advanced driver assistance or advanced driver assistance systems. That, for example, the auto brake function, the intelligent cruise function, they're all about technologies, although not quite to a level of autonomous driving. It better assists many drivers with different technologies, either for safety or to ease the burden of driving. So in looking into patents about advanced driver assistance, and this is again for U.S. patents, you're looking at a much smaller pool. We have about 1,200 patents from last 9 years or so. And again, when you look at patents in this area, they are heavily mostly owned by car companies or car component companies, with the runner-ups being Ford, Toyota, Magna, Bosch, and Microsemi. And this frequent players in the car industry. And looking at keywords, and this time we use a slightly different chart just because it's a smaller collection of patents. So looking at the inner loop or the inner pie diagram, you see the different categories relating to advanced driver assistance. So starting from the bottom right, you have, of course, driver assistance, but it does have many different subsets, including images and other type of processing. And moving clockwise from the driver assistance category, you can see just as autonomous vehicles, again, image data, data-related processing is very important to this type of technology. It's a very frequent keyword out of those 1,200 patents. And going further clockwise, you have mobile devices that relate to many communication functions. And going further down, you have computing devices, control units, and categories that involve the control of vehicles. So now you have a good understanding of the lay of the land, the leaders in patents in different areas. Anthony is going to share with us the litigations in this industry.
Thank you, Ming. While the number of litigations involving patents on autonomous vehicle technology is currently low, there appears to be an upward trend in patent application filings on technologies related to autonomous vehicles. Regarding litigation, the majority focuses on LiDAR technology, which functions as the eyes of an autonomous vehicle. According to one of the litigants we will be discussing, Waymo, LiDAR is a laser-based scanning and mapping technology that uses the reflection of laser beams off objects to create real-time 3D images of the world. So let's just get into it. We will first turn our attention to Waymo versus Uber, a litigation filed in the Northern District of California. Waymo asserted federal and state trade secret misappropriation claims along with patent infringement. The technology at issue is LiDAR. Waymo alleged that instead of outsourcing its LiDAR development, it uses its own LiDAR system it created internally. Waymo alleged that its proprietary LiDAR systems improve the ability of self-driving cars to navigate safely in all environments, including city environments and highly unusual driving scenarios. Regarding the trade secret misappropriation claims, as alleged in Waymo's complaint, Waymo was inadvertently copied on an email from one of its LiDAR component vendors attaching a machine drawing of an Uber LiDAR circuit board. The drawing allegedly resembled Waymo's allegedly confidential and proprietary design. Waymo also alleged that its former manager of its self-driving project downloaded more than 14,000 allegedly confidential and proprietary files shortly before he resigned. The complaint detailed how the former manager allegedly took almost 10 gigabytes of data and that the manager allegedly installed software to wipe his fingerprints from the data collection. Waymo further alleged that the manager had set up a competing company called Otto before leaving Waymo. After Otto launched, Uber acquired it for $680 million. This case was settled about 5 days into trial. Based on publicly available information, it appears that at least a portion of the settlement included a 0.34% stake in Uber. At that time, Uber was valued at $72 billion, leaving the settlement value at about $245 million. I regretfully do not have an estimate of the value today, considering Uber just went public. Let's turn our attention to the patents that were at issue. First, we address the 922 patent. In its complaint, Waymo alleged that this patent pioneered LiDAR systems with improved performance at lower costs by innovating a design that, in part, uses a single lens, rather than multiple sets of lenses, to both transmit and receive the collection of laser beams used to scan the surrounding environment. Waymo alleged this design greatly simplifies the manufacturing process by eliminating the need to painstakingly align pairs of transmit and receive lenses, with even a slight miscalibration of a lens pair affecting the accuracy of the system. Next, we address the 936 patent. According to Waymo, the invention in this patent improved the performance and lowered the cost of LiDAR systems for autonomous vehicles by simplifying the design of the laser diode firing circuit that is at the heart of any LiDAR system. Waymo alleges that it invented a design that elegantly simplified the circuit to control the charging and discharging paths of the lasers compared to the more complicated circuit designs otherwise used by the industry. The third patent that was asserted in the initial complaint was the 273 patent. Waymo asserts that this patent simplified a design for pre-collimating, or making parallel, the light output of each laser diode separately before the beams are combined. Waymo alleges that the increased compactness of this design increases the resolution of the overall LiDAR system. This is the fourth patent that was alleged in this litigation. I note that this patent was added later in the case in an amended complaint. The patent is directed to a rotating LiDAR device that transmits and receives light beams for detecting the location of surrounding objects. The claims are substantially like the claims in the 922 patent and are directed to the same LiDAR components. So as we can see, LiDAR is pretty important technology with respect to autonomous vehicles, and at least according to IAM Media, the top 5 patent assignees for LiDAR-related patents are Google Waymo, Continental Automotive, AI, Vallejo, and LeddarTech. This graphic shows who is filing the most patents in LiDAR technologies in each year. For example, in 2017, Luminar led the way. In 2016, it was Qualcomm. Baidu led the way in 2015, and Uber was at the top in 2014. Again, over 6,000 patent families related to LiDAR for automotive were filed. As you can see, there are a number of parties in the market, and this technology area is getting very crowded in the patent space. As LiDAR technology becomes more and more prevalent in the auto industry and other industries, we can expect to see an increase in litigation in this area. The next litigation I wanted to raise was the Quanergy System versus Velodyne LiDAR case, also filed in the Northern District of California. Quanergy also alleged trade secret misappropriation claims in this matter. Quanergy also filed a declaratory judgment claim of non-infringement of a Velodyne patent, a breach of contract claim, along with a constructive fraud claim. Again, the technology at issue is LiDAR. Quanergy alleges its LiDAR sensors enabled broad deployment of advanced driver system assistance, or ADAS, and autonomous driving systems. Quanergy alleged that its M81 LiDAR sensor is made for use with such system. Regarding the misappropriation claim, Quanergy alleges that it took steps to protect its trade secrets, including installing a tamper-proof seal on the outside casing of its M81 sensor, which leaves silver markings on the casing if it was removed or tampered with, thereby deterring and preventing unauthorized access to the confidential internal structure, design, assembly, and other contents of the M81 sensor. Quanergy also alleged that it requires each purchaser of its products to accept certain terms of sale that are included in the sales order signed by the purchaser. Included in these terms of sale is a provision that imposes use and disclosure restrictions to the purchaser. In the complaint, Quanergy alleges that it entered into an NDA with a third party seeking its technology. Quanergy then alleges that this third party shared its technology with its competitor, Velodyne. The litigation has been stayed for some time pending the outcome of 2 IPRs filed against the patent at issue. As you can see, the final written decisions are due in about a week in this case. The patent at issue is the 558 patent and is directed to rotating LiDAR system, and it was filed 6 years prior to Waymo's rotating LiDAR system patents, as discussed in the previous case. Claim 1 of the patent states that a LiDAR-based 3D point cloud system comprising a support structure, a plurality of laser emitters supported by the support structure, a plurality of avalanche photodiode detectors supported by the support structure, and a rotary component configured to rotate the plurality of laser emitters and the plurality of avalanche photodiode detectors at a speed of at least 200 RPM. As shown in the image, the LiDAR system includes laser emitters with corresponding detectors, both of which are supported by a rotatable structure. In this configuration, the entire LiDAR system can rotate quickly while atop a vehicle. The next two cases do not involve patents, but instead trade secrets. Given how the technology is still developing in these areas, many companies are opting to maintain their advancements through trade secrets instead of sharing their technology with the world. As you may infer, trade secret protection in this technology is just as valuable and protectable as in the patent arena. In the next case, we will discuss Tesla filed claims against defendant and former employee Guangji Cao for alleged trade secret misappropriation related to Tesla's autopilot semi-autonomous driving features, along with a breach of contract and a breach of employees' duty of loyalty. This matter was also filed in the Northern District of California. According to Tesla, Autopilot is a driver assistance system that offers features including lane keeping, adaptive cruise control, and automatic parking. More recently, Tesla allegedly introduced Navigate on Autopilot, which it alleges guides a car from a highway's on-ramp to off-ramp, including suggesting and making lane changes, navigating highway interchanges, and taking exits, in each case under the driver's supervision. Tesla alleges that Cao was a member of Tesla's Autopilot team, a group of engineers developing Tesla's Autopilot features, including its full self-driving technology. Tesla alleges that Cao had access to important and highly confidential Tesla information, including source code. They allege in the complaint that when Cao quit his job at Tesla, he had allegedly already accepted a job doing similar work for Xpeng Motors technology company, X Motors. X Motor is a Tesla competitor, which Tesla alleges imitates Tesla's design and technology, including an autopilot feature called X Pilot. While Cao was allegedly discussing potential employment with X Motors in the months prior to quitting his job at Tesla, Cao allegedly uploaded copies of Tesla's Autopilot-related source code to his personal iCloud account. Before his final day at Tesla, Cao allegedly deleted many files, cleared his browser history, and allegedly disconnected his iCloud account from his Tesla computer. Tesla alleges that Cao is now responsible for the self-driving research and development team of X Motors, and it allegedly joins at least 5 former Autopilot team members that left Tesla for X Motors. This matter is currently ongoing. Our final litigation slide focuses on WeRide Corp. Versus Kanhuang et al. This is another entity suing individuals on claims of trade secret misappropriation and other related claims in the Northern District of California. The technology at issue in this case is LiDAR again. WeRide alleges that it relies on software to perform perception, prediction, decision, and control functions integral to its product design. Perception functions involve the use of LiDAR technology, which is a hotly pursued technology in and of itself, as we've been discussing. Prediction functions try to anticipate the future path of each object the car encounters. Decision functions determine the car's next move to reach the car's planned destination, taking into account infrastructure, traffic laws, and other objects. Control functions translate decisions into actions, actuating components of vehicle systems, such as steering, drivetrain, fuel, and braking systems. WeRide alleges that its former CEO, Jing Wang, resigned and allegedly signed a separation agreement promising to abide by terms of his employment agreement, preventing him from disclosing proprietary information or soliciting employees of WeRide for 1 year. In an alleged violation of this agreement, Wang recruited Huang, who, before he left WeRide, allegedly downloaded several gigabytes of confidential WeRide information and retained it. WeRide believes Wang and Huang, news company AllRide, is using the information allegedly taken from WeRide to develop self-driving technology. This matter is also currently pending. As discussed earlier, litigations relating to this newly developing technology and field of autonomous vehicle is slowly evolving. Based on number of parties involved in patenting technologies in this area, as Ming discussed earlier, we expect to see an uptick in litigations and IPRs as the area develops and as the technology becomes more prevalent in the industry. To that, we will now address IP strategies for innovators in this industry. As an initial point, we remind all innovators to consider protecting all aspects of their IP. For patent filers, be sure to engage in best practices to protect the technology you intend to seek patent protection on. This would include developing invention disclosure protocols at your company, conduct invention audits with your technical folks, maintain a system of keeping track of patentable ideas. Just as important in maintaining patents is maintaining your trade secrets. It is always a difficult decision when trying to determine whether to protect a technology through trade secret versus patent. The party should always type of technology and what will likely provide the most protection. As you are likely aware, patent protection provides you a limited number of years of protection in exchange of disclosing your technology to the world. Where trade secrets can go on indefinitely, but they must be tightly controlled. Once a trade secret is made publicly available, it is out there and there's not much a company can do about it. To that, there are several different ways to maintain trade secrets. A diligent party should always conduct trade secret audits, consider creating an invention review committee, maintain a trade secret inventory, and probably most importantly, develop policy and procedures for trade secret management, including enlisting a compliance officer to keep track of the trade secrets, offering employee training in both identifying and protecting trade secrets, enlisting strong security, both physical security at the location of trade secret as well as cyber security concerning the availability now of different types of files like PDFs or source code files or AutoCAD files that could easily be taken and removed. Make sure to enter into contracts and NDAs regarding specific protections for trade secrets, and ensure limited access to the trade secrets, meaning keeping folks on a need-to-know basis. You don't need to share every piece of information and every secret of the company with everybody at the company. Frankly, I could do an entire day of trade secrets, but we should move on. Parties must also be cognizant of protecting both their brand of products for trademark protection. For example, we had mentioned the Tesla Autopilot vehicle offerings. Auto companies and manufacturers of auto components should be very cognizant of their protection of their brand and their name to make sure that other competitors are not taking advantage of the goodwill that they build. There's also the ability to copyright different things like source code, user and technical manuals, and etc. The user and technical manual copyright protection is important if there's any fear that you may have either some sort of knockoff or copycat company taking your product and bringing it to market. As a friendly reminder, all of these IP protections can be enforced both in district court, as we have discussed, but is also available for protection at the United States International Trade Commission. Additional strategies to consider are competitive surveillance. You want to be sure to stay on top of what your competitors may be doing. Aside from developing protections for innovations, you will want to be sure to keep an eye on what innovations your competitors are protecting. Freedom to operate and clearance opinions are as important to you as you develop your products to make sure that you can put your product onto market without having any disruption with your customers. Another issue to consider is the evolution of technology. You want to be sure to consider not only what is valuable now versus what will create value 5 years from now. You need to be protecting for the future, not just the present. Furthermore, everyone in the industry should also be watching as standards begin to develop. We will touch upon standards in the next section. The industry also needs to consider new business models. With all these autonomous vehicle technology, what will individual consumers continue to purchase or lease vehicles, or will the model change to service providers providing automotive transportation? As you consider protecting your IP, you want to be considerate of what new business models may be developing. If you were to tell me 10 years ago that there would be a company like Uber out there making share ride available for everyone, I would have been surprised. Now it's the standard. Finally, new technology comes with new security considerations. As vehicles become autonomous and smart, what security factors are the developers putting into place? No one wants to be in a vehicle that may be potentially hacked. There will need to be innovations in the security areas commensurate with the technology we have been discussing today. With that, I will turn it over to Phil.
All right. Well, thanks, Anthony. Thanks, Ming. That was a great presentation. So at this point, let's move along now to our question and answer segment of the webinar. But before we dive in, we'd like to remind the audience to please take a moment to complete our brief evaluation survey. As we strive to provide programs of value and continually improve, we would appreciate your input, which will guide us in planning our future programs. Okay, so now it's time to address some of the questions that we received from the audience. And just as a reminder, to submit a question, just click on the Q&A button and type your question into the Q&A window, and then just click Submit. It looks like we have a few questions here, but given our time constraints today, we may only be able to get to a few of them. Of course, we'd love to answer each and every one of them individually, but we'll do our best. We'll try to work through a few of them here and now. But if you'd like, you can also please feel free to contact me and Anthony if you submitted a question. If we are unable to address it today, and they'd be glad to discuss it with you offline. Okay, so turning to our first question, here it is. Thinking of the current business model for car sales in which most people own or lease their car, do you foresee that business model changing as autonomous cars become commercially available? And if so, how might that change in business model impact IP strategies for automakers and suppliers? So Anthony, would you like to start us off answering that question?
Sure. I just touched upon this a minute ago, but I can expand a little bit on what I was saying. So autonomous driving technology may foster the introduction of new service-oriented business models, such as autonomous taxis, ride shares, group rides, or even rental cars. It may also have a significant impact on the concept and need of car ownership. As such, more people may switch to using driving services instead of owning their own car, while existing or future corporations may become the purchasers of vehicles to supply the demand. While this may reflect a change in the buying habits of consumers, something which will be felt by the auto manufacturers, this change may not have a significant impact on IP strategies in and of itself. What do you think, Phil?
Well, one thought on that is that we may start to see automakers focusing on new, let's call it user experience aspects of autonomous vehicles, which may open up a new area for IP focus. So for instance, automakers may seek to provide new solutions to complement the various things that a passenger might focus their attention on now that the car is driving itself and the driver is not working so much to operate the vehicle. So, as a few examples, for travelers, it may be robot-piloted guide tours as a replacement for traditional human-guided tours. For daily users, it might be music services or video services, internet access, remote working tools, etc. Several things. Automakers may bundle these types of features with car services, which may affect how we develop our IP strategies. So, subscription-based subscription-based car services, or if you will, the Netflix of cars, could be the types of things that automakers start to investigate and develop IP strategies around. So let's go ahead and take another question. Here's a second one. The issue of standards essential patents has come up in the discussion surrounding autonomous vehicles. And while this topic is probably big enough to fill an entire webinar by itself, do you have any quick thoughts on what may be some focal areas of standards development for autonomous vehicles? Ming, would you like to handle this one?
Oh, certainly. Standards are already critical to many things we use. Also texting, surfing the net, talking on the phone, streaming videos, or even sharing photos. They all involve standards. And standards becomes even more critical for the future of transportation because there are many more rules, many more communications, and a lot of needs for common protocols among the vehicles driving on the road. So one such example is vehicle-to-vehicle and vehicle-to-infrastructure communications. Self-driving cars become safer when they talk to each other. And rather than predicting what each other car may do, they actually can talk to each other and know exactly what each other will do in the next 2 seconds. So that's vehicle-to-vehicle communication, and it's becoming an important safety feature, but it can also be an important efficiency feature. So in addition to cars talking to each other, in the earlier part of the presentation, you also saw patent publications about how cars are interacting with other entities. So, for example, cars can communicate with pedestrians, can communicate with infrastructures. cyclists, or even human drivers. And the communications can be in different forms. So the various forms of inter-vehicle or inter-entity communications enhance many things, and I would say by many, many times. So one good example is collision avoidance, and another one is hazard warnings when there is certain condition on the road that affects everyone's safety. Also, at the same time, when cars are communicating better with each other, there would be ways of optimizing traffic flows, increasing fuel efficiency, and reduce travel time. So standards, it's fair to say, will be everywhere in the future of cars, and which also explains why many of you already saw the news from 2 weeks ago that there is an alliance of 3 car companies, Toyota, Ford, and General Motors, in developing standards relating to self-driving cars.
Thanks, Ming. Just as a quick follow-on to your answer, I note that many of these issues are safety-related as it relates to standards. So it seems like we could see numerous safety-related aspects of autonomous cars becoming standardized as those technologies develop. For example, the imaging technology used for seeing a vehicle's surroundings, such as the types of LiDAR and camera technologies that Anthony discussed previously in the recent litigations, these types of things may be eventually standardized to some extent, at least, in order to ensure a certain level of effectiveness once the technology has been sufficiently developed. So do you agree with that, Ming, or what are your thoughts on that?
Yeah, Phil, I think you're right. Safety is priceless and therefore drives the technology development in many areas. But I also would add that in addition to safety, when people are thinking about the future of transportation, and as we can see from some of the earlier examples, there are also solutions about using different technologies, solutions to improve efficiency, and most importantly, because all of us are human, there are solutions to enhance our experience as a passenger to self-driving cars.
Okay, great. Thanks a lot, Ming. So I guess I'll go ahead and move us along to our next question, and here it is. So there are obviously many aspects of autonomous vehicles that will be supported by the development of cutting-edge software, but what about hardware? So Anthony, is hardware particular to autonomous vehicles worth pursuing still from an IP strategy point of view?
Oh, absolutely. Autonomous vehicle development may lead to the design of new and improved hardware components, such as motors and actuators for controlling the moving parts of a vehicle that were once controlled by humans, such as accelerating, braking, and steering. To the extent autonomous vehicles will allow for manual override of automated functions, including accelerating, braking, and steering, the hardware for supporting those systems may be specially designed for use in autonomous cars. Additionally, to the extent internal combustion engines and hybrid electric drivetrains are both used in combination with autonomous driving systems, engines and motor technology may continue to focus areas for IP protection. One additional area of technology to consider with all of this is the Internet of Things, which will allow all of these components to talk to one another.
Yeah, I agree, Anthony. And furthermore, it's possible that we could start to see new user interfaces inside the cockpits of autonomous vehicles that may draw on the protections of both utility patents and design patents. So much like the recent cell phone technology litigations that were based on design patents, which many of you are probably familiar with, autonomous cars could also involve the implementation of combinations of hard and soft user interfaces that may be best protected by either or both of utility patents and design patents, depending on the particular features that they employ. So let's go ahead and move on to one more question. Looks like we have a little bit of time still. So here it is. Several people have analogized the race to commercialize autonomous cars to the patent wars in the cell phone technology space that resulted in numerous high-dollar litigations. However, many have noted that automakers have traditionally not been very litigious with their competitors. So Ming, do you think that the autonomous car race will change the behavior of automakers with respect to their traditional approach to litigation?
Things may become very different because just from the earlier part of the presentation we have seen about the leaders in different technologies, we are now seeing many other new players in the field. While a large number of automakers still own many patents to these rising technologies, you're seeing more and more new players, and you'll see a lot more in the future, especially when it comes to cars. And these players are getting traction, they're patenting new technologies, and I think these players may have a different philosophy of how this market may operate. And a good example is several of the patent publications I shared earlier during today's presentation, they all came from companies who don't make or sell cars. And these companies are likely to have business strategies that can be unique to their own needs. And those business strategies can be very different from those of traditional car companies. And therefore, you're talking about new thinking, new business strategy about technology partnerships, about licensing of patents, about know-hows, and about litigations as well. So several of the litigations Anthony shared earlier also suggest that patent and trade secret litigations are becoming very common. Companies delivering autonomous vehicle technologies and companies developing AI, software, LiDAR, computer vision, ride services, they represent new business models. They may not be so inclined to look the other way when competitors are using their protected technologies or when the competitors are competing unfairly in some other ways. So it's fair to say that, yes, in the past, the car companies haven't been litigious. But in the new world of transportation, because of new players, new technologies, and new rules, I think we're dealing with a world that may be very different in terms of IP strategies, IP litigations, and their cross-license or license behaviors.
Thanks, Ming. That was a great answer. That takes us to the end of our Q&A section for now. And as I mentioned earlier, anybody who had a question that we weren't able to address today, please feel free to reach out to Ming and Anthony, and they'd be happy to take the discussion offline. So at this point, I'd like to thank you all for attending today's webcast. This is Cars and Patents, IP Trends, Strategies, and Autonomous Driving Patents Landscape. Just a quick note about the presentation. It will be available on demand in the next week. So please look for an email from us with access to the link. And thanks again for joining us. This concludes today's Finnegan webcast. So thank you for participating.